These are the lawsuits that could end science as we know it. Not through legislation, not through defunding, but through something far more insidious, suing the scientists themselves until they shut up. Over the past decade, a troubling pattern has emerged across courtrooms in the United States and Europe. Powerful corporations and wealthy individuals are wielding litigation like a weapon, targeting researchers who publish findings that threaten their bottom line. The strategy has a name. It's called a SLAPP suit, a strategic lawsuit against public participation, and its purpose isn't to win in court. Its purpose is to bankrupt, exhaust, and terrify anyone who dares speak inconvenient truths backed by data. The term was coined back in 1996 by law professor George Pring and sociologist Penelope Kanan. 3 decades later, the problem has metastasized. The Business and Human Rights Resource Center has documented 355 legal cases bearing the hallmarks of SLAPPs since 2015. In Europe alone, 570 SLAPP cases were identified over a 10-year period. The fossil fuel industry has been particularly aggressive. A 2022 report from Earthrights International found the industry used SLAPP tactics to target more than 150 people and organizations in just 1 decade. And the targets aren't faceless institutions. They're individual scientists, people with families, mortgages, and careers that can be destroyed by a single lawsuit they never asked for. Let's start with the most famous case. Michael Mann is one of the world's best-known climate scientists. In the late 1990s, he and his collaborators published groundbreaking research showing a sharp increase in global temperatures linked to greenhouse gas emissions. The visualization of this data became known as the hockey stick graph, and it became one of the most iconic and contested images in climate science. For years, Mann faced relentless attacks. The barrage intensified after ClimateGate in 2009, when leaked emails from the University of East Anglia were selectively quoted to manufacture a scandal. Multiple investigations cleared the scientists of wrongdoing, but the damage to public perception was done. Then, in 2012, things crossed a line. Rand Simberg, a fellow at the Competitive Enterprise Institute, published a blog post that compared Mann to Jerry Sandusky, the convicted child molester and former Penn State football coach. The exact words were that Mann could be said to be the Jerry Sandusky of climate science, except instead of molesting children, he has molested and tortured data. Mark Stein, a conservative writer for National Review, amplified those comments. Mann did something almost no scientist had ever done before. He sued. 12 years later, in February 2024, after a day of deliberations, a jury ruled that Simberg and Stein had defamed Mann. He was awarded more than $1 million in damages. As Kurt Davies of the Center for Climate Integrity put it, there's never been a case like this. No one has ever taken the climate deniers to court like this. Mann himself said something that should resonate with every researcher watching. We all pay the price when scientists don't feel empowered to speak out about the implications of their science. But here's where it gets complicated. In March 2025, Judge Alfred Irving reduced the award to just $5,000 and imposed sanctions against Mann's legal team, accusing them of making false statements about Mann's grant money during the trial. Mann's team says those charges are false and unfair. At a time when the Trump administration is scaling back climate programs and rolling back environmental rules, the ruling sends a troubling signal. Now let's talk about someone you've probably never heard of. Chelsea Polis is a reproductive health epidemiologist and principal research scientist at the Guttmacher Institute. In 2018, a company called Valley Electronics published a study in the journal Reproductive Health promoting their product, the Daisy Fertility Tracker. Polis examined the study and found serious methodological problems. She raised concerns publicly, as scientists are supposed to do when they find flawed research that could affect people's health. By May 2019, the journal agreed and retracted the study. Valley Electronics responded by suing Polis for defamation. She was served the lawsuit papers in May 2020, right in the middle of the COVID lockdown. The courier couldn't even get past the security desk of her apartment building. It was, as she described it, a very strange situation. For more than a year, Polis faced the stress and expense of defending herself against a lawsuit designed not to prove she was wrong, but to punish her for being right. Arnold and Porter represented her pro bono, and in August 2021, the case was dismissed. In March 2022, a New York appeals court sided with Polis, finding Valley's lawsuit to be without merit. Polis later said it was a blatant attempt to try to silence me, merely for speaking truth to try to protect people and their reproductive health. She added, "When we are hit with lawsuits for doing so, it risks creating a chilling effect that may discourage scientists from speaking on matters of public interest." In 2023, she was awarded the John Maddox Prize for defending science in the face of corporate litigation. But for every Chelsea Paulus who fights back, how many researchers simply go quiet? The most staggering case in terms of sheer financial stakes involves Energy Transfer, a Dallas-based pipeline company, and Greenpeace. During the 2016 and 2017 Standing Rock protests against the Dakota Access Pipeline, Greenpeace was among the organizations supporting opposition to the project. Energy Transfer first filed a federal RICO lawsuit seeking $300 million. A federal judge dismissed it. Undeterred, the company filed again in state court in North Dakota in 2019. In March 2025, a North Dakota jury delivered a verdict finding Greenpeace entities liable for more than $660 million. A final judgment in February 2026 set the amount at $345 million. Greenpeace has announced it will seek a new trial and, if necessary, appeal to the North Dakota Supreme Court. Sushma Raman, interim executive director of Greenpeace Inc., called it a renewed push by corporations to weaponize our courts to silence dissent. Greenpeace also took the fight to Europe, filing the first test of the European Union's anti-SLAPP directive in Dutch court against Energy Transfer in February 2025. Then there's the case that flips the script entirely. Carlo Croce, an oncologist at Ohio State University, once described himself in a deposition as the pope of the genetics of leukemias and lymphomas. When the New York Times published a front-page investigation in 2017 raising questions about his research, Croce didn't respond with data. He sued the Times for defamation. He also sued David Sanders, a Purdue University scientist who had criticized his work. Both lawsuits failed. The Times case was largely dismissed in 2018. Croce lost both appeals in 2019 and lost the Sanders case in 2020. By 2022, he was ordered to pay his own lawyers more than $1 million in unpaid legal fees. His art collection was seized and sold by the state of Ohio to cover the debt. A scientist who used the legal system as a weapon was ultimately destroyed by it. The numbers tell a clear story about where this is headed. Lauren Kurtz of the Climate Science Legal Defense Fund says they helped over 50 researchers in 2023 alone, breaking their own record, and the targets are expanding. While climate researchers were the early victims, the attacks have now spread to biomedical scientists, supercharged by the COVID-19 pandemic. Peter Hotez, a professor at Baylor College of Medicine, warns that young people considering scientific careers are watching all of this unfold and asking themselves why they would ever enter a profession where publishing your findings might land you in court. Currently, 35 states have laws designed to reduce the harm of SLAPP suits. The EU adopted an anti-SLAPP directive in 2023. The UK has been slower to act, despite the fact that the assassination of Maltese journalist Daphne Caruana Galizia, who had 48 libel suits pending against her when a car bomb killed her in 2017, served as a catalyst for European reform. The question at the center of all this isn't really a legal one, it's an existential one for science itself. If publishing a peer-reviewed paper can cost you your savings, your career, and your peace of mind, then the peer review system doesn't protect anyone. The courtroom becomes the place where scientific debate is settled, and in the courtroom, the side with the most money almost always has the advantage. Science has always depended on the freedom to be wrong, to challenge, to question, to publish findings that powerful people don't like. The moment that freedom carries a price tag most researchers can't afford, we've already lost something we may never get back.